The current challenges relates to the statutory guidance which the Scottish Government issued in 2022, following a successful legal challenge to the statutory definition of a woman in the 2018 Act and to the original statutory guidance. In the revised guidance, the Scottish Government, relying on its interpretation of the Equality Act 2010, asserts that woman, for the purposes of the 2018 Act, includes a trans woman who possesses a full gender recognition certificate, acknowledging her required sex as that of a woman. The campaigning charity For Women Scotland challenged the legality of that statutory guidance and submit that it is both wrong in law and beyond the competency of the Scottish Government. This challenge was rejected by both the Outer House and the Inner House of the Court of Session in Edinburgh. The courts held that Section 9.1 of the Gender Recognition Act 2004, which I'll now refer to as the GRA, had the effect that a person with a gender recognition certificate was entitled to be treated in law as having his or her acquired gender for all purposes. They addressed Section 9.3 of the GRA, which provides that the rule in Section 9.1 is, and I quote, subject to provision made by this Act or any other enactment or any subordinate legislation. The courts held that Section 9.3 has effect only if the terms and context of the subsequent enactment require it to be interpreted as disapplying the Section 9.1 rule. They held that the Equality Act 2010, which I'll now refer to as the EA, did not require such an interpretation except possibly in the provisions relating to pregnancy and maternity. For Women Scotland appeal to this court. Their appeal is opposed by the Scottish ministers. We have also had the benefit of submissions from 4 interveners. First, there is Sex Matters, a campaigning charity which argued cogently for a biological interpretation of the words woman and sex in the EA. Secondly, the Lesbian Project and the LGB Alliance, which are also campaigning charities, pointed out the anomalies which would adversely affect lesbians if those terms were interpreted as certificated sex rather than biological sex. Thirdly, we had submissions from the Equality and Human Rights Commission, which I'll refer to as the EHRC, a British public body which has advised the Scottish Government on the interpretation of the EA. The EHRC supported the Scottish Government's interpretation of the EA, but expressed concerns about anomalies in the operation of that Act and concluded that the EA needed to be amended by Parliament. Fourthly, Amnesty International UK provided submissions on human rights issues relevant to the appeal. We are grateful to all the interveners for their assistance. In a judgment written by Lady Rose, Lady Simler and me, with whom Lord Reid and Lord Lloyd-Jones agree, we unanimously allow the appeal. It's a long judgment, as the court analyses the GRA and the EA in considerable detail. In a hand-down address, I can only give a brief description of the reasoning. The court explains the principles which apply to statutory interpretation, including the need to give a coherent meaning to an Act of Parliament. By way of historical background, we point out that the Sex Discrimination Act of 1975, which is the relevant statutory predecessor of the EA, adopted a biological interpretation of the terms man and woman. The Sex Discrimination Gender Reassignment Regulations, 1999, which I'll call the 1999 Regulations, introduced a new protected characteristic of gender reassignment, which protects those who intend to undergo, are undergoing, or have undergone a process of gender reassignment. The 1999 regulations did not alter the definitions of man or woman in the Sex Discrimination Act. The judgment then addresses two central questions. The first is the meaning of the GRA. As I have said, the Scottish courts applied the rule in section 9.1 of the GRA to the definition of woman in the EA, as they didn't interpret the EA as qualifying that rule. So the first question is therefore, what is the meaning and effect of section 9.3 of the GRA? The court rejects the submission that for section 9.3 to operate, it is necessary to find an express statutory provision disapplying section 9.1, or that the other statute by necessary implication disapplies the section 9.1 rule. We hold that all that is required is that the words of the other legislation, when interpreted carefully in their context and having regard to their purpose, are found to be inconsistent with that rule. That conclusion leads on to the second central question, which is whether the provisions of the EA are inconsistent with the rule in section 9.1 of the GRA. Answering that question involves a painstaking analysis of those provisions. Having conducted that analysis, which takes up the majority of our judgment, the court has concluded that the provisions of the EA are inconsistent with the rule in section 9.1 of the GRA. We have summarized our reasoning in paragraph 265 of the judgment. The principal elements of our reasoning can be summarized in the following 9 points. First, the EA enacts group-based protections against discrimination on the grounds, among others, of sex and gender reassignment, and imposes duties of positive action on employers and others. Secondly, the EA must be interpreted in a clear and consistent way so that those on whom the Act imposes obligations can identify the groups which share a protected characteristic. Thirdly, interpreting sex as certificated sex would cut across the definitions of man and woman in the EA, and thus the protected characteristic of sex, in an incoherent way. It would create heterogeneous groupings. Fourthly, as a matter of ordinary language, the provisions relating to sex discrimination, and especially those relating to pregnancy and maternity, and to protection from risks specifically affecting women, can only be interpreted as referring to biological sex. Fifthly, we reject the suggestion that these words can bear a variable meaning, so that in the provisions relating to pregnancy and maternity, the EA is referring to biological sex only, while elsewhere it refers to certificated sex as well. This undermines the coherence of the statute. Sixthly, the interpretation favoured by the EHRC and the Scottish ministers would create two subgroups within those who share the protected characteristic of gender reassignment, giving trans persons who possess a gender recognition certificate greater rights than those who do not. Those seeking to perform their obligations under the Act would have no obvious means of distinguishing between the two subgroups to whom different duties were owed, particularly since they could not ask persons whether they had obtained a gender recognition certificate, as that information is private. Seventhly, the certificated sex interpretation would also seriously weaken the protections given to those with the protected characteristic of sexual orientation, for example, by interfering with their ability to have lesbian-only spaces and associations. Eighthly, other provisions will function properly only if sex is interpreted as biological sex. Those provisions include separate spaces and single-sex services, including changing rooms, hostels, and medical services, and communal accommodation. And ninthly, similar incoherence and impracticability arise in the operation of provisions relating to single-sex characteristic associations and charities, women's fair participation in sport, the operation of the public sector equality duty, and the armed forces. Standing back, we note that the EHRC has advised the United Kingdom government of problems created by the certificated sex interpretation of the EA. Those problems include several matters in the 9 points which we have described. In our view, the absence of coherence within the statute and the practical problems which arise demonstrate that that interpretation is not correct. It follows that the interpretation of woman in the Scottish Government guidance on the 2018 Act is incorrect, and the challenge to that guidance succeeds. It also follows that the 2018 Act, correctly interpreted, is within the legislative competence of the Scottish Parliament. Finally, as I flagged up earlier, the correct interpretation of the EA as referring to biological sex does not cause disadvantage to trans people whether or not they possess a gender recognition certificate. Trans people have the rights which attach to the protected characteristic of gender reassignment. In addition, as we explain between paragraphs 248 and 263 of the judgment, they have protection against direct discrimination, harassment and indirect discrimination by association with members of the sex with which they identify. A trans woman can bring a claim alleging sex discrimination because she is perceived to be a woman or by her association with women. It is now well established that direct discrimination because of a protected characteristic encompasses not only cases where the complainant affected by discrimination has the protected characteristic in question, but also where the discriminator perceives that the claimant has the characteristic or in some way associates the complainant with the protected characteristic. A trans woman is similarly protected against harassment under Section 26 of the Equality Act. Further, the principle of discrimination by association remains part of our law, see Section 19A of the EA, and protects transgender people against indirect discrimination, regardless of whether they possess gender recognition certificates. A certified sex reading is not required to achieve any relevant purpose in relation to indirect discrimination. For these reasons, the court allows the appeal.